Hi, everyone. I'm Diane Macedo. We're coming on the air with breaking news. In a major First Amendment case, the Supreme Court has ruled 8-1 in favor of a former high school student punished by her school after posting a vulgar video on social media. The school had accused then 14-year-old Brandy Levy of breaching a code of conduct and suspended her from cheerleading for an entire year after seeing a curse-filled video rant she posted after she didn't make the varsity cheerleading squad. Justice Breyer wrote the opinion in this case, concluding that, quote, while it might be tempting to dismiss the student's words as unworthy of First Amendment protections, sometimes it's necessary to protect the superfluous order in order to preserve the necessary. Joining me with more on this, let's go to senior national correspondent Terry Moran, senior Washington reporter Devin Dwyer, and on the phone, Supreme Court contributor Kate Shaw. Devin, I'll start with you. One of the big questions in this case was whether the school could apply its code of conduct for speech that happens off campus. So what are the practical implications of this decision, particularly with the prevalence of social media now?
Well, this is a win for Brandy Levy. We went up to Pennsylvania a few weeks ago, Diane, and met with her. She's not going to be surprised by this decision. 2 lower federal courts said the school went too far here in punishing her for this vulgar tweet. She said after hours in line to get a Dairy Queen on a weekend several years ago. She's graduated now. She wants this case behind her. So she's already won. She was reinstated to the team. This was really about, as you suggest, the standard that schools will be able to use going forward. And here, it was actually a small win for the schools. Justice Breyer rolled back a sweeping appeals court decision that said schools have zero power to regulate student speech anytime the students are off campus. Here he said there actually are some circumstances when they can regulate student speech, particularly cyberbullying, threats, online cheating. Those are the circumstances. Schools don't have no power to regulate student speech. Is just very limited.
Kate, how did the justices reach this decision?
So, Diane, when they're deciding a case, obviously they're resolving the dispute between the parties in front of them, but they're sort of setting out broad principles for future school administrators, students, parents as well. And so here what they sort of did was say, we're going to basically take this long-standing Supreme Court precedent that says students don't shed their free speech rights at the schoolhouse gates. They still get the protection of the First Amendment when they enter a public school. But schools do have significant authority to regulate speech by students if that is substantially disruptive, if it's going to hurt the educational environment. So the students have rights, but the schools do get to regulate some exercise of student speech. So what the court basically did here was extend that reasoning to student speech that happens off campus. So basically saying students do enjoy the protections of the First Amendment when they're, engaging in speech with their peers and friends. But schools do have, as Devin was saying, some regulatory authority if student speech is disruptive, if it involves cheating, if there are threats or bullying. So it's the court doing a kind of a delicate balance that preserves strong speech rights for students, but also gives pretty significant authority and discretion to school administrators to regulate where they need to protect the educational environment of students.
So, Terry, it sounds like a lot of this will come down to whether or not this off-campus speech in future meets a certain bar that the school will have to decide, and ultimately the courts will have to decide if a case like this comes back into court.
That's right. There's an old saying in the law that hard cases make bad law, that judges trying to remedy something in a difficult case might go too far. Petty cases like this one. This is somebody complaining they didn't make the cheerleading squad, and it was on Snapchat, which is a social media where the message disappears after a certain time. But while it was still there, one of the young ladies, one of the girls in the school, took a picture of it, showed it to the cheerleading coach, who was quite offended. And so this is the pettiness of a coach who was offended at this curse-laden rant by this young lady who did not make the cheerleading squad. And now it's in the Supreme Court. In answer to your question, why do students give up First Amendment rights to some degree? Why do schools have power? In order to afford to preserve the educational mission of the school. Any speech that might disrupt the school to such an extent, the school's educational mission and purposes it can be regulated by the school. Threats, and you can imagine kind of on social media, anybody who's a parent of a young person today knows that it's very different when I was at school. When I was at school, you went home and you left school behind. Now, right, you bring school home, and you bring school on, you bring your home rants onto the school property. And so that's what made this case difficult and interesting. But at the core, Justice Breyer maintains, and the court holds with the exception of Justice Thomas, that the school's regulation of student speech must remain tethered to that educational mission. That if there is a bona fide, legitimate educational reason to limit school speech, that it's so disruptive or so threatening or so deeply offensive, the school may, although he didn't really outline when, step in and limit that speech. In this case, all the courts who have looked at it said this is pettiness, and the school doesn't have that right. But the Supreme Court here does acknowledge that off-campus speech sometimes might reach that level of interfering with the school's educational mission.
So, Devin, given there seems to be a lot of gray area in this decision, what's the likelihood we see a case like this go before the courts again?
And we know there are some already percolating, Diane. The ACLU has been leading the way on this. But we heard a lot, and we will hear more today, no doubt, from the schools, the principals associations, the superintendents associations, who really feared this case for what they said would be handcuffing their ability to keep kids safe, to keep the learning environment protected, as Terry and Kate were talking about. You know, and even in sports teams and extracurricular activities, we interviewed a number of coaches who worried that codes of conduct that students agree to as part of these teams, as was the case here, Brandy Levy agreed to a code of conduct not to speak ill of the team, the school, or anyone else in the sport. After hours, on campus, you name it. They say she broke that agreement, which she made with the school. Schools are worried today, and will take some time to have to figure out how this shakes out, whether they'll be able to enforce those policies going forward as well, Diane.
And Kate, an 8-1 decision here by the Supreme Court. We've seen a large number of unanimous decisions by the court. What does this decision do for the general, just that the court seems pretty united overall right now?
It has been striking over the course of the last few weeks as these high-profile decisions late in the term have come down. And I think that, we weren't sure whether this was a trend that was just, illusory because the late decisions were going to break along familiar kind of ideological lines. And we just really haven't seen that materialize. So I do think that the justices seem to be working very hard to reach unanimous or close to unanimous results in these cases, even difficult and often divisive ones. And it's hard to know exactly what that's about. I mean, there's been a lot of public attention to the court and discussion of Supreme Court structural reform, talk of court packing. There's a view that has an impact on the justices, that they don't want the Congress or the public mucking around in the court trying to impose term limits or changing the size of the court. And to the extent that they can send a message that they're not just an ideological body, that potentially they may, be able to diffuse some of that attention or interest. So I think there's a view that this is actually kind of strategic, maybe both to ward off potential interference with the court, but also to send a message more broadly to the public that the court is, to a large extent, operating outside of politics, doing something different than just implementing the political or ideological preferences of the justices. So I do think it seems to be the case that the justices on both the left and the right of the court are working pretty hard to try to, stay together on these big cases and to send that message to the public. We still have another 8 cases to go, and a couple of them remain fairly divisive, including a big voting rights case. So we'll see how that shakes out. But I do agree it's been a striking trend this first full term with this newly composed, very conservative court, reaching a lot of pretty moderate compromise positions.
And Terry, as the court seems to send out this message that it is the apolitical body it was intended to be, at least right now, Justice Breyer is getting a lot of pressure from Democrats to retire while Joe Biden is in office and in the early part of his tenure in office. What's the latest on that?
Well, Democrats, of course, remember Ruth Bader Ginsburg, who had fought cancer for decades successfully. But towards the end of her life and career on the court, there was concern that she should retire while there was a Democratic president, while Barack Obama was president. And she did not. And to the surprise of many people, Donald Trump was elected president, and the rest is history. They don't want to repeat that history, Democrats. So they're pressuring Stephen Breyer, who's 82 years old and in fine health, but They're looking ahead to the possibility that the Republicans could take the Senate next year. And Mitch McConnell has already said publicly that he will not confirm. He'd stand in the way, as he did with Barack Obama, of a Supreme Court justice confirmation, certainly in 2024, the election year, maybe even in 2023. He might just stop confirming Supreme Court justices. And with that in mind, what the Democrats are saying to Justice Breyer is leave now. Leave now. And in fact, there's a truck going around the Supreme Court with a billboard on that says, "Retire, Breyer." He has pushed back on that, and in fact, in some ways, that kind of pressure, there's a letter from law professors, some progressive law professors saying the same thing, that could just get him to dig his heels in if he had any thought about it at all. It is entirely up to justices when they leave. The Constitution gives them life tenure, except for if they were to be impeached for some reason, and he shows no signs of going, but you never know.
All right, Terry Moran, Devin Dwyer, Kate Shaw, always great to have you. Thank you all.
Thanks.
And again, the Supreme Court just upheld a major First Amendment decision citing in favor of a high school cheerleader who had been suspended from the squad over a vulgar Snapchat video. The court citing that speech was protected under the First Amendment.
Hi, everyone. George Stephanopoulos here. Thanks for checking out the ABC News YouTube channel. If you'd like to get more videos, show highlights, and watch live event coverage, click on the right over here to subscribe to our channel. And don't forget to download the ABC News app for breaking news alerts. Thanks for watching.